Professor LeBlanc, as we await a possible decision from a BC Supreme Court judge with respect to who's in control of Rogers Communications, talk to us about what happened in the courtroom. What are the elements that stood out for you?
Much of the debate, Larysa, centered around 4 words, and the words were "at the same meeting." Rogers and the family members are arguing that you need to have a shareholder meeting in order to replace directors. Mr. Edward Rogers is arguing that under the Act, the British Columbia Corporations Act, he can replace directors with a resolution. So the judge will interpret those 4 words. So you never like lawyers dancing on the head of a pin in terms of interpreting words. Judges do not make law. Judges interpret law. And I think given the questions by Justice Fitzpatrick yesterday, my sense is that she's leaning to black letter law. And in fact, Mr. Rogers does have the authority to replace these directors. That is what I would expect given yesterday's dialogue on Friday.
Let's get into that a little bit. Indulge us here. Give us a quick 101 with respect to a black letter of the law, or more commonly as it's known, a letter of the law.
Black letter law is it simply means that it's for a strict constructionist, a conservative judge, I'm just looking at what's in front of me. I can't look at what's not there. So that was my sense from listening to the questions and the debate yesterday. But the underlying problem, Larysa, is the Act in British Columbia. I mean, I'm a corporate governance professor. I've never heard of not having a meeting to replace directors. That's the most important shareholder obligation at a meeting is to replace directors. So the Act in British Columbia is defective. It's the only act in Canada that enables directors to be replaced without having a meeting. So I thought that was very odd. That's the source of the problem. Is the Act is defective, number one. Number two is the voting trust that enables Mr. Rogers to act with 97% of the votes. And number three is dual class shares. So we almost have a trifecta, which is a perfect storm of a defective act, dual class shares, and a voting trust. And the consequences of that, Larysa, is that Mr. Rogers, if the judge rules in his favor, can replace these directors.
From what I understand, both sides submitted affidavits. Among them was a memorandum of wishes. Can you explain to us what that is, and does that hold legal footing?
Well, the judge seemed to poo-poo that and said that, in fact, case law suggests that decedent, this is not the word she used, this is my word, that decedents can be unhelpful. I think in trust law, settlers, their intentions are very important. And one of the Rogers lawyers had those memoranda or a piece of it read into evidence, which means the judge must consider it. Because Ted Rogers, in his memoranda, this is the intention of the settler, which is very important. As I said, he wanted a shareholder meeting. He wanted earnest consultation with beneficiaries, including the mother and both sisters. He also wanted regular rotation of the chairship of the trust. And Mr. Edward Rogers has held this position since 2008. So a very strong argument can be made by family members and by Rogers that, in fact, Mr. Rogers is not abiding by the spirit of Mr. Ted Rogers.
Is there clarity as to why Rogers, the company, is incorporated in British Columbia?
That's an interesting question. And that was asked to the counsel for Mr. Edward Rogers. And the counsel, as I recall, didn't have an answer. I think later in the day, it was disclosed that that's where the company started, in British Columbia. But it's interesting that British Columbia is, as far as I know, the only statute that permits this sort of mechanism, I think, as Rogers put it a number of weeks ago, to enable replacement of directors. One lawyer yesterday, Larysa, said, what's to stop Mr. Rogers from doing this 6 months from now, replacing more directors? I think that if Mr. Rogers is enabled by Friday's ruling, he doesn't have to wait 6 months. He has the authority and the power to appoint himself as CEO. And if any other director doesn't like that, he can remove them as well. It is unbridled, unfettered use of discretion and power that I've never seen in almost 30 years of corporate governance. This is not what legislators intended. So the British Columbia Securities Commission and indeed the British Columbia government should be seized of this case and say, really, is this what we intended, for one person to control the governance of a large public company? We have institutional shareholders. We've got retail shareholders. This is very significant.
Professor, what do you make of the timing of the decision, of a possible decision by the end of the week, at the end of the day? I believe it's 5 p.m. Eastern. Is that curious? Is that interesting for you?
It's interesting that it's on a Friday and it's at the close of markets, 5 p.m. Eastern, 2 p.m. Pacific. But I think that Justice Fitzpatrick is seized of this case. There is a claim to 2 valid boards, which is unsustainable. I think she is aware, the Justice Fitzpatrick, that time is of the essence. I think that on Friday, she has indicated that she would come out with a ruling. She may not come out with written reasons, but we will have, I predict, a weekend of flurry starting at 5 p.m. I would not at all be surprised if appeals are being prepared by both sides to launch at 5 p.m., regardless of what the outcome is. And we're probably in for a weekend of meetings and a flurry and of disruption that will continue not just into the weekend, but this could, if Mr. Rogers has to have a shareholder meeting, this could go on for the next few months. Let's
talk about, you've just laid out the possible scenarios with respect to the letter of the law. But beyond that, I mean, there is still, you used a word not too long ago, spirit, the behavior. How does this go on? How does this family business continue?
Well, putting aside the legal and looking at the behavioral, directors post dispute, and I regularly advise boards, I tell them, listen, if you cannot accept the will of the majority, you need to stand down from the board. You have to get past this dispute. You've got to orient towards compromise. And the issue here is entrenchment of positions, dislike, intense, visceral dislike among family members, among independent directors. I don't think behaviorally this board is ready, whatever valid board it is ready to govern. I think we might see more shoes to drop, which is director resignations or further infighting. What investors want to see, Larysa, is a board that speaks with one voice, not 14, family members that can get along, and a board that is effective at the oversight of management and preparing for the Shaw merger. What has occurred is there is pushback on the CRTC ruling on the Shaw merger. And Bell has supported this by public interest groups. And what they're saying is that Rogers, as a company, is not prepared to oversee this merger because of all of the infighting. So the infighting has come at a real cost to the merger possibly not being completed or not being approved.